More now on our breaking news. A second judge has ruled that the Trump administration must use emergency funds to at least partially cover SNAP benefits in November. Remember, 42 million Americans depend on these benefits for groceries to feed themselves and their families.
Yeah, so many people. And Renee Marsh is following this. Renee, what else are we learning? A very quickly moving story here.
Yeah, so these two judges, one in Boston and one in Rhode Island, making these decisions just really just minutes apart. And so what we have here at this hour is that these two federal judges are aligned in saying that the Trump administration is required to tap into this emergency fund that is sitting at the USDA that contains close to $6 billion. They must tap into that fund to keep SNAP benefits going. If you remember, the Trump administration said because of the shutdown, they had spoken to states and told them that payments would not be made on November 1st.
Okay, so what I am about to tell you is something that has never happened before in the entire history of the United States of America. We are in completely uncharted territory right now as a country, and I need you to understand just how significant this moment is for Trump and for the country and for the future of American democracy itself. The Supreme Court, the highest court in the land, just destroyed Donald Trump's final escape route from his criminal conviction. They rejected his last-ditch emergency request to stop his sentencing in the New York hush money case. And now, for the first time ever, we have a sitting president of the United States who is a convicted felon heading towards sentencing with virtually no legal options left to avoid potential imprisonment. But before we go any further, real quick, let's be honest. You can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video.
Judge in Rhode Island essentially ordered them to release these funds as soon as possible. Worth noting that the close to $6 billion will not cover all that is needed to fund SNAP throughout the country. That costs about $9 billion per month. And so this judge said that the agency would also have to figure out if they would agree to look to move other money from the agency to supplement what is needed so that every American who relies on this program will get funds. Last point that is super important, that if you're watching and you're a part of this program, what does this all mean for whether you will have these funds starting tomorrow?
Let me say that again because I really want it to sink in, and I want you to understand the gravity of what is happening. A sitting president of the United States, a convicted felon on 34 separate counts, heading toward criminal sentencing, with no remaining legal off-ramps available to him. This is unprecedented in every sense of the word, and we are watching it unfold in real time. No president in American history has ever been in this position before. No president has ever been convicted of felonies while serving in office. No president has ever faced the realistic possibility of actual prison time while simultaneously running the executive branch of the most powerful nation on earth. And yet here we are watching it happen right before our eyes. Here's what went down at the Supreme Court and why it matters so much for everything that comes next in this historic situation. Trump was convicted in New York on 34 felony counts related to falsifying business records. These charges stem from hush money payments made to adult film actress Stormy Daniels during the 2016 campaign to keep her quiet about an alleged affair before the election. Trump's lawyers have been fighting this conviction through every possible legal avenue for months now, trying to delay or overturn the verdict. They have filed motion after motion in multiple courts, appeal after appeal at every level available to them. They have tried every trick in the legal playbook to delay sentencing and avoid any form of accountability for the crimes he was convicted of. Their final play, their absolute last option, was to go directly to the Supreme Court with an emergency request, asking the justices to step in and halt the sentencing before it could happen. Trump's legal team argued that his actions were protected by presidential immunity under the Constitution. They claimed that proceeding with sentencing would be fundamentally unfair while he was serving as president of the United States. They essentially asked the highest court in the land to give him a get-out-of-jail-free card based solely on the office he currently holds. And the Supreme Court looked at that request carefully and said no. They rejected it completely. They refused to intervene on his behalf. They let the New York judge proceed with sentencing exactly as scheduled. Think about what that means for a moment. and let it really sink in. Trump went to the Supreme Court, the court that has 3 justices he personally appointed during his first term, and asked them to save him from criminal accountability. And they said, no, we will not do that. Even a conservative majority Supreme Court that has been favorable to Trump on many other issues refused to step in and rescue him from this conviction. That tells you something really important about how weak his legal arguments actually were in this case. It tells you that even judges who are sympathetic to Trump and his political agenda could not find any legitimate legal basis to intervene on his behalf. Here, the implications of this decision are absolutely massive and will affect everything going forward for Trump and for the country. First and most importantly, Trump's status as a convicted felon is now effectively locked in permanently for this case. He has exhausted his appeals at the highest level possible. There is nowhere else to go. The conviction stands as a matter of law. He is a convicted criminal, not allegedly, but actually convicted by a jury of his peers on 34 separate felony counts. That is his permanent record, now regardless of what else happens in his life or his presidency. Second, and this is crucial, the sentencing options the New York judge has available include real jail time as a possibility, not just fines, not just probation. Actual imprisonment is on the table as a realistic option the judge can impose. Now, legal experts say that for a first-time nonviolent offender like Trump, the most likely outcome is probably probation or a fine rather than prison. But the point is that prison is a legal option the judge can impose if he chooses to do so based on the circumstances. A sitting president of the United States could theoretically be sentenced to serve time in jail. That is where we are as a country right now. Third, and this is crucial for understanding the bigger picture of Trump's legal exposure, this hush money case is only one of multiple criminal prosecutions Trump has been facing since leaving office the first time. He has dealt with federal election interference charges related to his attempts to overturn the 2020 election results. He faced racketeering charges in Georgia connected to the same conduct. While some of those cases have been delayed or complicated by his return to office, the New York case is moving forward regardless. And the Supreme Court's refusal to intervene here sends a powerful signal to judges and prosecutors in those other matters as well. All right, so let us get into the specifics of what happened at the Supreme Court and why this decision is so devastating for Trump and his legal strategy going forward. The details here matter a lot because they show just how desperate Trump's legal team has become over the past year and how thoroughly the courts have rejected their arguments at every single level they have tried. So here's the background on how we got to this unprecedented moment in American history. Trump was convicted in New York in 2024 on 34 felony counts for falsifying business records in the first degree. The charges related to payments made to Stormy Daniels through Trump's former personal lawyer, Michael Cohen. The prosecution argued convincingly that Trump directed Cohen to pay Daniels to keep her quiet about an alleged affair right before the 2016 election, when the story could have damaged his campaign. Then Trump reimbursed Cohen for those payments, and his company falsified business records to disguise what those payments were actually for. A jury of 12 ordinary citizens heard all the evidence presented by both sides and found Trump guilty on every single count the prosecution brought against him. After the conviction, Trump's lawyers immediately began working overtime to delay sentencing and eventually overturn the verdict on appeal through any means necessary. Their primary legal argument has been presidential immunity, the claim that Trump cannot be prosecuted or punished for actions connected to his role as president of the United States. They pointed to the Supreme Court's 2024 ruling in the case of Trump versus United States, which established that presidents have immunity for many official acts taken while serving in office. They argued aggressively that this immunity doctrine should apply to the hush money case and should protect Trump from prosecution or punishment. Here is the fundamental problem with that argument and why courts have rejected it at every single turn so far. The Supreme Court's immunity ruling drew a very clear distinction between official presidential acts and private personal conduct by the individual. Official acts taken in your capacity as president in the course of your duties might be protected from prosecution, but private conduct, things you do as a private citizen that have absolutely nothing to do with your presidential duties, is not protected at all under the immunity doctrine. The hush money payments to Stormy Daniels happened before Trump was even president. They were made during the 2016 campaign when he was just a private citizen running for office. There is nothing official or presidential about paying hush money to cover up an alleged affair with an adult film actress. So when Trump's lawyers went to the Supreme Court with their emergency request in January, they were essentially asking the justices to extend immunity protection to purely private conduct that occurred before Trump even took office the first time. The justices looked at that argument carefully and said, no, that is absolutely not what our immunity ruling means or was intended to mean. We drew a clear line between official and private conduct for a very good reason. In this hush money case, falls squarely on the private side of that line. We are not going to bail you out of this situation. The timing of Trump's request to the Supreme Court is also worth examining carefully because it shows just how desperate his legal situation has become over the past months. He filed his emergency application in early January 2025, just days before his scheduled sentencing date. This was a Hail Mary attempt to stop the process at the absolute last possible moment before sentencing occurred. It was the legal equivalent of throwing everything at the wall and hoping that anything would stick. And when the Supreme Court rejected his request on January 9th, 2025, it meant the sentencing could proceed exactly as the New York judge had originally scheduled. Now let us talk about what this conviction and upcoming sentencing actually mean in practical terms, because a lot of people are understandably confused about the possible outcomes Trump faces. The 34 felony counts Trump was convicted on all relate to falsifying business records in the first degree. Under New York state law, falsifying business records in the first degree is classified as a Class E felony offense. Each individual count carries a potential sentence of up to 4 years in prison, but sentences for multiple counts can run concurrently, meaning served at the same time rather than consecutively one after another. So Trump is not facing 136 years in prison or anything remotely close to that maximum theoretical number. Legal experts who have analyzed the case thoroughly say the realistic sentencing options for Trump include several different possibilities that the judge could choose from. The judge could impose probation with conditions attached, meaning Trump would not serve any jail time, but would have to follow certain rules and check in regularly with a probation officer. The judge could impose substantial fines, which would be financially painful, but would not involve any incarceration whatsoever. The judge could order some form of community service or alternative sentencing arrangement. Or the judge could actually sentence Trump to serve time in jail, either in a traditional correctional facility or under some form of house arrest or home confinement arrangement. Most legal analysts who study these cases believe that probation or a fine is the most likely outcome for a first-time nonviolent offender in Trump's situation. Courts generally do not send people to prison for falsifying business records when they have no prior criminal history and the underlying crime did not involve any violence against anyone. But here is the thing that makes this particular situation completely unique. Unlike any other case, Trump is absolutely not a typical defendant by any measure. He is a former president who has shown open contempt for the legal system throughout these entire proceedings. He has publicly attacked the judge and the prosecutors and the jury members. He has repeatedly violated gag orders designed to protect witnesses. He has shown zero remorse whatsoever for his conduct and instead constantly portrayed himself as an innocent victim of political persecution. Judges consider all of these behavioral factors carefully when deciding what sentence to impose on a defendant. They look at whether the defendant genuinely accepts responsibility for what they did. They look at whether the defendant shows any remorse for their actions. They look at whether the defendant respects the legal process and the authority of the court. Trump has failed spectacularly on all of these measures throughout his trial and afterward. That could potentially influence the judge toward imposing a harsher sentence than a typical first-time offender might receive under normal circumstances. We simply do not know yet exactly how the judge will weigh all of these various considerations when making his decision. What we do know with certainty is that the Supreme Court's refusal to intervene removes the last major legal obstacle to sentencing going forward on schedule. Trump has no more federal appeals remaining on the immunity question. He cannot delay the process any further by claiming he needs to wait for higher courts to rule on his arguments. The conviction is effectively final for purposes of proceeding with sentencing. Whatever additional appeals he files going forward will happen after the sentence is imposed rather than before, meaning he will have to face sentencing first. The Supreme Court decision also sends an extremely important signal to judges and prosecutors handling Trump's other criminal cases around the country. The federal election interference case in Washington, the Georgia racketeering case in Atlanta, the classified documents case in Florida. Prosecutors in all of these matters have been watching very carefully to see whether the Supreme Court would rescue Trump from accountability in the New York case. Now they have their definitive answer. The highest court in the land is not going to step in and save him from facing consequences. That emboldens prosecutors to push forward aggressively with their own cases, knowing that the judiciary will not simply defer to Trump's wishes because he holds or previously held the presidency. The broader legal landscape for Trump is honestly terrible when you step back and look at the full picture objectively. He has been convicted of 34 felonies in New York by a jury of his peers. He faced serious federal charges in Washington related to election interference schemes. He faced federal charges in Florida related to mishandling classified documents. He faced state charges in Georgia related to election interference. While some of these cases have been delayed or complicated by his return to the presidency, the underlying conduct he is accused of remains the same, and prosecutors have made abundantly clear they intend to pursue accountability whenever legally possible. Okay, so let us break this down into what it actually means going forward for Trump and for the country, because there is so much happening here, and the implications are truly enormous. We are in unprecedented territory as a nation, and everyone needs to understand what is at stake and what comes next in this historic situation. Point number one that everyone absolutely needs to understand about where we are right now in this moment. Donald Trump is a convicted felon heading toward criminal sentencing, with no remaining legal escape routes at the federal level available to him. The Supreme Court was his absolute last hope for avoiding this moment, and they said, no, we will not help you. They refused to intervene on his behalf. They let the conviction stand as valid. They allowed sentencing to proceed on schedule. This is not a situation where Trump can credibly claim he is still fighting and might win eventually. He lost at every level of the court system, in every court that heard his arguments. The conviction is final, and he will be sentenced by the New York judge in the coming days. This makes Trump the first president in American history to be a convicted criminal while actively serving in office. Think about what that means for the dignity of the presidency and for America's standing in the world among our allies and adversaries. The person wielding the most powerful executive authority on earth has been found guilty of 34 felonies by a jury of American citizens. That is who is making decisions about nuclear weapons and foreign policy and the economy every single day. That is who is representing America on the world stage in meetings with foreign leaders, a convicted felon occupying the Oval Office. There is no precedent for this situation and no playbook for how to handle it constitutionally. Point number two about the realistic possibilities for sentencing and what might actually happen when Trump appears before the judge for his sentencing hearing. The options on the table range from relatively minor consequences, a fine or probation with conditions, to genuinely serious punishment, actual jail time in a correctional facility. Most legal experts who follow these cases closely think prison is unlikely for a first-time nonviolent offender in this type of case, but the judge has very broad discretion in sentencing, and Trump's conduct throughout these entire proceedings has been extraordinarily disrespectful to the court and the legal system. He has attacked everyone involved publicly. He has violated court orders repeatedly. He has shown absolutely zero remorse for anything he did. Judges notice these things very carefully when they decide what sentences to impose on defendants who appear before them. They are supposed to consider whether the defendant genuinely accepts responsibility for their actions and whether they are likely to commit similar crimes again in the future. Trump has made abundantly clear through his public statements that he believes he did nothing wrong whatsoever and that the entire prosecution was nothing but a politically motivated hit job against him. He has promised to pardon himself and take revenge on everyone involved in prosecuting him when he has the chance to do so. That is absolutely not the profile of someone who has learned their lesson and deserves leniency from the court. Whether that influences the judge toward imposing a harsher sentence remains to be seen. Point number three, about what happens if Trump is actually sentenced to jail time while serving as president of the United States. This is where we enter truly uncharted constitutional territory that absolutely nobody knows how to navigate because it has never happened before. Can a sitting president actually be in prison while still holding office? Who would have legal custody of him in that situation? What happens to his Secret Service protection if he is incarcerated? What happens to the nuclear codes and his ability to respond to national emergencies? What happens to his constitutional ability to perform his presidential duties from a jail cell? There are no clear answers to any of these fundamental questions because nobody who wrote the Constitution ever imagined we would be in this situation. Some legal scholars argue that a president cannot practically be in prison while still in office because incarceration would interfere with his constitutional duties as commander-in-chief and head of the executive branch. Others argue that the Constitution does not explicitly exempt presidents from criminal punishment and that jail time should apply to them exactly like it would apply to anyone else convicted of the same crimes. There is also the complicated question of whether Trump could simply pardon himself for federal crimes, though that would not help him at all with this New York State conviction, since presidential pardons only apply to federal offenses and have no effect on state criminal cases whatsoever. We are in genuinely unprecedented territory with serious constitutional implications. Point number four, about what the Supreme Court decision signals for Trump's other criminal cases and his broader legal exposure going forward. The justices' refusal to rescue Trump from the New York conviction sends a powerful message to everyone involved in his other prosecutions around the country. The message is crystal clear. The Supreme Court is not going to simply bail out Trump whenever he asks them to do so. Courts are going to apply the law as it actually exists. Prosecutors can proceed with their cases knowing that the judiciary will not intervene to protect Trump from accountability just because he holds or held the presidency. This matters enormously for the federal cases and the Georgia case that have been delayed or complicated by Trump's return to office as president. Prosecutors now know they have a green light to push forward aggressively whenever legal circumstances allow them to do so. Judges know they do not need to defer to Trump's claims of immunity or special treatment simply because of who he is. The highest court in the land has spoken clearly, and they have said that Trump is not above the law, at least when it comes to private conduct, completely unrelated to his official presidential duties. What really strikes me about this moment is what it reveals about the current state of American democracy and the rule of law in our country. We have a president who has been convicted of serious crimes by a jury. We have courts that are proceeding to hold him accountable despite his enormous power and his threats against everyone involved. We have a Supreme Court that refused to rescue him, even though he personally appointed 3 of its 9 members. The system is working slowly and imperfectly, to be sure, but working nonetheless to demonstrate that no one in America is above accountability, regardless of how powerful they are. That does not mean the outcome is certain or that justice will ultimately be served in the end. Trump still has enormous power to disrupt and delay and attack the legal system at every turn. He can use his presidential authority to interfere with federal prosecutions, even if he cannot stop state cases like New York from moving forward. He can rally his supporters to pressure judges and prosecutors through threats and intimidation. He can create chaos and confusion that makes accountability much harder to achieve. The battle is far from over. Here is what I want to leave you with today as you think about what all of this means for our country. The Supreme Court's refusal to save Trump from his conviction is a truly historic moment for the rule of law in America. It establishes that even presidents, even sitting presidents, can be held criminally accountable for their private conduct. It establishes that immunity does not extend to crimes committed as a private citizen before taking office. It establishes that the courts will not simply defer to presidential power when fundamental principles of justice are at stake. What happens next will test whether American institutions can actually follow through on holding a powerful person accountable for their actions. Trump will be sentenced. He may appeal further, though his options are now very limited. He may try to use his presidential power to interfere with other cases against him. He may attack the judges and prosecutors involved through his public platform. He may try to pardon himself or find other creative ways to avoid facing consequences. The question is whether the system can withstand that pressure and deliver something resembling justice in the end. The Supreme Court's ruling suggests it can, at least in this particular case, but the larger battle over accountability and the rule of law in America continues. All right, that is it for today, folks. This is genuinely historic stuff we are living through, and there will be much more to cover as the sentencing proceeds and Trump responds to whatever punishment the judge imposes. Hit that subscribe button if you have not already. Drop a comment below and let me know what you think about all of this. Do you think Trump will actually face jail time? Do you think the system can hold him accountable? I want to hear your thoughts, and I will see you in the next one. Stay informed and stay engaged. This is history unfolding before our eyes. Peace.